Hi everyone, Lawrence Hugo, Credit Mediation Service. Hope you're all well. I'm at my son's gymnastics lesson at the moment, so I thought I'd take 5 minutes to do this clip and talk about the subject today, which is legal action. What is it that the banks can do in terms of legal action to collect on a credit card that the consumer refuses to pay or is not able to pay? So there's two broad categories to speak to first. The first is the business or commercial category and the consumer category. Now with the business category, it's a very different set of rules on how banks approach legal recovery compared to consumer. With commercial, they tend to keep it in-house in pursuing legal action. No, I'm not going to go into great detail. I'm not going to go into any detail about that today because that's a whole new kettle of fish. The consumer side is very, very different. As a rule, with the odd exception, banks generally don't take litigation action against a consumer for unpaid credit cards or personal loans. The reason why they don't do that, unlike the old days, is because of costs. It's much easier for them to take that unpaid credit card that's 6 to 12 months in arrears, outsource it to a debt collection agency. The debt collection agency, they're going to be their problem. The agency will buy the debt for 20, 30, 40, 50 cents on the dollar, and the agency will then take on the burden of the legal costs to pursue the consumer. So, and there are exceptions to that, but as a general rule, that's what happens. And so the unpaid credit card migrates over to the debt collection agency. They look at the file. What do they do? So if the consumer refuses to pay or is not able to pay, and the consumer is not willing to cooperate and dialogue with the debt collection agency, the agency then makes a decision. What are we going to do with this? If we're going to litigate, they do a due diligence. Does the consumer have property? Do they have a full-time job? Are there means for them to pursue the consumer to make them pay the full amount in the short term? They're looking for homes. They're looking for full-time wages, and so they'll begin the process by issuing a letter of demand. They'll give the client at least 30 days, even though there's less time. But they generally give them 30 days to respond to that. And then from that point, they can issue a statement of claim or a statement of liquidated claim, which is basically a summons to court. And with this summons to court, it's not really a court action. What it is a declaration that they intend on applying for a judgment in the courts, and it's an opportunity for the consumer to place a defence on this claim. So the consumer usually doesn't place a defence and a judgment's obtained. Now the debt collection agency, they spend somewhere in the region of $2,000, $2,500 in getting to this point. Once they're at this point, they want to get their money back, and they want to get their $2,000 back plus the principal. And so they'll then proceed with further legal action, but again, they've got to revisit the due diligence and work out what is it we're going to do. If the consumer is working full-time, then their option will be to do a garnishee of wages. And that's different. It might be an attachment called an attachment of earnings or something. It just depends state by state on what their options are. So they might ideally, and the quick bucks for them, the easiest way for them to collect their money is to issue a garnishee order. And that means that it's a court-imposed order on the pay office of the consumer that they've got to deduct X amount from the consumer's pay before they receive it. Bit of a rude shock, but if one refuses to pay or refuses to dialogue, there's not much choice that the debt collection agency has. The other option the debt collection agency will have is bankruptcy, which is pretty messy, but if the consumer has a property and there's enough equity in the property, then it might well be worthwhile for the debt collection agency to proceed with bankruptcy. Then of course we've got the writ of execution, and the writ of execution essentially is a much more refined bankruptcy in a sense. So a sheriff will attend the consumer's address, put stickers on assets that could potentially be seized and sold off at the auctions. Not a very pretty way to deal with it, and usually it's unsuccessful because there's very few assets that legally the sheriff is allowed to take. But what they're looking for is the 100-year-old grandfather clock. They're looking for the vintage Mustang in the garage. They're looking for something that can be taken off the consumer to be sold. More often than not, the RIT can be applied to a property, and the property can then be seized and sold to pay the debt. All very messy, not very pleasant, and the consumer has plenty of opportunities to interdict this process by setting up agreements and payment arrangements, which is ideally what the debt collection agency would usually want. There's a lot more to this, and there's lots of things, and I'm going to be talking about how it is you can deal with these at each stage and how to deal with these this legal procedure in another clip. But I will finish off by saying that if you are experiencing any kind of issues with a debt collection agency in terms of legal action, seek the service of a lawyer to get good advice. And of course, this is not legal advice, this is not financial advice, but this is just a quick step-by-step process on what the banks do and debt collection agencies do in terms of collecting their debts through the legal procedures. Thank you. See you guys. Bye.